going to talk a little bit about the performance test process. Then we're going to walk through it a little bit for the February 2024 PT. So I'm going to walk you through the steps a bit for that particular performance test. For those of you that have just joined, I'm going to put the link to the materials for the February exam in the chat, so you can grab that there. Also, just a quick mention, for those of you that are, really wanting to improve your PT score, rather, our full classes get started next week. For the California performance test, that starts next Thursday, and I'll put a link to the course in the chat. Also, I wrote and released a little over a year ago a performance test book for California. A lot of people like it because of my breakdowns of everything, in particular, color coding, showing you really how to do the analysis. You get my marked up file in the library to see and compare when you do a PT, did you extract the same rules that I did, etc. So I put the link to the book in the chat as well, so that you can check that out. And it's available in digital, or it's available in hard copy as well. So just as a heads up on that. Sorry, my dog Archie likes the PTs too, so he's chiming in here. All right, so that being said, let's do a little bit of an overview of the performance test process. So goals for today, we're going to understand the February 24 California PT, and we're going to understand the performance test process. So I'm going to walk through this a little bit right now, and then we're going to dig into the February PT. So the very first thing you do with when you get the PT, well, for California, you get in the afternoon the performance test, and you get 2 essays and the PT. People often ask me if they should start with the PT. I don't think that you should. I think you should just go in order, do the 2 essays, push through them, and then get to the PT. And the reason for that is it is so tempting to borrow time and put extra time on the PT. And I just don't want you to take away from your essays. So I'm of the mind that you should just go through, do everything in order, and put your 90 minutes on the PT. So with the PT, the first thing you do is you review the task memo. There's 5 things that you want to get from the task memo, which I'll talk about in just a minute. Then after you review the task memo, I want you to set up your PT skeletal outline. I want you to set that up. So put in your intro, your conclusion, your macro headings. For a lot of people were thrown off because the PT said, don't include an intro and conclusion. Fine. Not a big deal. You don't do those things. It just saves you a couple of minutes, and you have a couple more minutes for the analysis, but not a big deal. That just means like an intro section and a conclusion section. You still would have a conclusion as to the issues within the body of your performance test. If you're not given the issues from the task memo and you need to figure out, well, what the issues are, if it references a document, so if they say, we are going to look at, I want you to respond to arguments raised by opposing counsel in their motion or whatever, then you're going to go and look at that material in the file, because that will give you your organization. If they don't give you the organization, though, in the task memo, and it doesn't reference another document, you're probably going to have to organize based on the law, and that you get from the library. That is something that you had to do for the February 24 PT. After you do your setup, which we're going to do for the February PT, you skim the file. You're just trying to pull out relevant information. This is a step that you can skip if you are somebody that tends to run out of time, or if you get really sucked into the file. So you have to really pay attention to you and know how your timing is at every single step. On that note, something that I am doing for this upcoming bar, one of the things that I see is that people just really need to get that practice. They need that timed practice. I think it's incredibly important. And so I'm doing these sessions on Sundays, not every Sunday. It starts on June 2nd. One of them we will do, well, other than the last 2, I'm not telling you what we're doing in the last 2 sessions. There are 7 of these sessions where I'm going to give you the materials and you're going to show up. You're going to have 3 hours to write either 3 essays or 2 PTs. And then you'll take a break, and then I'll actually go over in about an hour. I'll outline what you needed to address in the fact pattern. So what issues did you need to address legally and factual issues as well, all of that stuff. So these will be available. You can get them session by session. I put the link to the bundle to get if you want to get all of them, but you can also just do each single session. If you click through on that link on the bottom, it lists each session individually too. So like here's the link to the very first one. So just as a heads up, the first one is on June 2nd. All right, so then after you skim the file, I want you to skim and read the library. We're going to do this a little bit this evening. This is a really important skill to be able to do this within the time structure here, about 15 minutes, to read each case with a purpose, understand what you're using the case for, focus on the analysis of each case, because when you focus on the analysis of the case, you will understand our case better. Because when you focus on the analysis, you will have facts of a similar nature in our case as we do in the cases in the library. And so we really want to focus on that because we are going to be either analogizing to or distinguishing from the facts in the cases. Somebody asked in the sessions, the Sunday sessions, yeah, you'll get the essays so that you can print them. They will be posted about 24 hours in advance. I don't want people to have a ton of time to actually do them in advance and look at them, but they will be posted about 24 hours in advance of the session so that you can print them. Yes. All right. So skimming and reading the library. After that, you're going to draft your rules, draft your rule proofs, which is where you explain the cases. In my full course, I go over this a lot deeper. Then you read the file, about 15 minutes to do that, and write the analysis. Where you're comparing the facts from our case to the facts of the cases in the library. And it's really comparing it to the analysis. You're also applying, if there are statutes, you're applying the law to the facts of our case as well. Then time permitting, you would proofread. I don't usually spend 5 minutes proofreading. I don't usually spend the 5 minutes. I will usually spend more like 1 to 2 minutes proofreading. And really when I proofread, I'm checking my headings mostly. And I put as much time as I possibly can towards the analysis. And just as a heads up, so if you want to join, I put the link to the essay sessions, or it's the Sunday sessions, really. I put the link in here in the chat for all of them. They're $25 a session, which is here if you want to do all of them. And then if you scroll down here, you'll see the subjects that we're going to cover. And then you can buy if you just want to buy like 1 or 2 or whatever. We're doing PTs. You'll do 2 PTs on June 23rd. And then on the bottom here, there's definitely going to be some PT coverage in these mixed sections too. All right, so we are going to dig into the February 2024 California PT now. Y'all should be able to see what's on my iPad, which is the February 2024 materials. I'm going to scroll down to the PT. So it's Panko V to here. One thing I want to point out is the PTs is instruction 4. So this is a change they made to the bar exam a couple of years ago. And instruction 4 says what you need to pay attention to is this. Facts are sometimes ambiguous, incomplete, or even conflicting. As in practice, a client's or supervising attorney's version of events may be incomplete or unreliable. Applicants are expected to recognize when facts are inconsistent or missing and are expected to identify sources of additional facts. So you should always be on the lookout for a factual issue like this and be ready to address it if it's there. I just wanted to point out that particular instruction because not everybody is aware of that. Okay, so we have here our task memo. This is our task memo. When I get to the task memo, I always write in the top corner, TAPOS, which is T is for tone. Is it objective or persuasive? A is for audience. Who am I writing to? P is the product. So am I writing a memo, a brief, closing argument, letter to opposing counsel, letter to a client? What am I writing? O is my organizing principle, which I'm going to talk about this in a minute. And S is for any special instructions. So these are the 5 things that I'm looking for when I get into doing the PT. So here, Anton Panko brought a negligence action against our client, John DeHere. So this is our client. Mr. DeHere and Mr. Panko were injured in a vehicle accident after DeHere stopped at the scene of a prior vehicle accident and Panko collided with his vehicle. Discovery has been completed. We will now file a motion for summary judgment on defendant's behalf, supported by a persuasive brief, arguing that there was no triable issue of material fact, that Panko's action is barred by Colombia's Good Samaritan Act, and the defendant is entitled to judgment as a matter of law on that basis. I have attached relevant portions of the previous discovery. Please draft a memorandum of points and authorities to support the motion. So we're doing a brief. The document that is attached to the brief is a memorandum of points and authorities, which is a persuasive document. Do not include an introduction, a section on the factual background and procedural history, or a conclusion, though obviously you should incorporate the facts into your argument. I will draft them after I edit your memo. So let's go back to this. Tone, this is persuasive. Audience is we're writing to the court. Product is P&As, so memorandum of points and authorities, which is just basically like a brief, if you want to think about it that way. Organization, they don't tell us the issues yet. They don't tell us the issues, so I've got to figure that out. I know that we're moving for a summary judgment and that we have to show that there is no triable issue of material fact and that the action is barred by Colombia's Good Samaritan Act. So whenever there's an MSJ, you want to incorporate that. So it's going to be what is required under Colombia's Good Samaritan Act. So I'm probably going to organize by the GSA, but I don't know what that really looks like yet. A lot of people, I've been having meetings with people and looking at their materials. A lot of people thought that they should do, there's no tribal issue of material fact, that Panko's action is barred by Colombia's Good Samaritan Act. So they did this as one issue. And then there was an and here, which I get why you would break it down this way. And 2, the defendant's entitled to judgment as a matter of law on that basis. The reason I don't organize it this way is because that's just stating the standard for an MSJ. And you want to argue that there is no tribal issue of material fact for each element, for each issue under the Good Samaritan Act. So it's just slightly different. When they give you a standard for a motion, you want to just constantly show there's no tribal issue of material fact for each issue that is each legal issue. So I'm going to organize by the GSA, special instructions, no intro, statement of facts, or conclusion. Does everybody understand why I'm not organizing by the way that I numbered here? There is no tribal issue of material fact. So whenever you have a standard for a motion, you want to just incorporate that standard into each issue. You don't break it up by the standard. So the standard applies to every issue. So essentially, as soon as I see this, or if I have any motion, I'm going to do essentially, my organization will look like this, where it's, so let's see, it's argument. I want to give my rules. So I'm going to give my standard for MSJ. And then I'm also going to give here the Good Samaritan Act. And then I would break it down. So like issue 1 under the Good Samaritan Act, issue 2, I don't know how many issues there are yet because I haven't gotten into the materials just yet. So issue 1, and then I would do issue 2, etc. So whenever they give you a motion, you don't organize by pieces of the motion, you incorporate the standard for the motion in each issue. So just throwing that out there. But I've seen plenty of people that have gotten a passing score on the PT, even though they broke it down based on, this, that it's barred by the GSA. and that you're entitled to judgment as a matter of law on that basis. So it's okay. I just do it a different way, and I wanted to explain the reason why. Does that make sense? Can y'all let me know in the chat? I just want to be sure. If y'all are unclear on it, let me know because I can address it a little bit more. Just let me know in the chat, please, because I've only gotten a few responses. So a lot of people need a little bit more of an explanation. So whatever you have, any standard, but particularly for a motion for summary judgment, whenever you have any sort of standard, you have to show that that standard is met for any legal issue. The Good Samaritan Act, once we get into the library, we're going to see that there's really two arguments, 2 points. And I want to show that for the first issue, there's no tribal issue of material fact such that we are entitled to judgment as a matter of law on issue 1. And issue 2, there's no tribal issue of material fact such that the defendant is entitled to judgment as a matter of law. So it's really just that what all they stated here in this section, all that the bar examiner stated here was the standard for an MSJ and the legal issue, which is the Good Samaritan Act. So you had to recognize that this is the standard for an MSJ. Even though there's an and there, it doesn't mean that that's like a separate legal issue. So you do need to know, this is why civil procedure is so important. That's why whenever anybody is in any of my bar prep programs, I have them start with civil procedure because it's everywhere. It's all over the bar exam. So it'll maybe make a little more sense as we get into this too, for those of you that are having a hard time with it. I want to do a quick setup. So I am going to open a Word doc. Actually, I've got it open. Okay. Somebody asked, should you assume the standard even when it's not explicit? It really depends on the document. But yeah, if you're filing a persuasive document and there is if you're writing a motion, then you want to argue that you meaning the standard required by the motion. Yeah. So y'all should see a blank Word doc. So first of all, this is my memorandum of points and authority. It's basically a brief. So defendant John Behere's memorandum of points and authority in support of motion for summary judgment. And I'm just going to label my argument section. And then I don't really know what else I have here. I'm not going to write an intro. I'm not going to write a conclusion. But I do know, and I'm going to make some shorthand notes in here. I do know that I'm going to have my standard for an MSJ here. And so I'm going to have MSJ. And I'm also going to have the Good Samaritan Act, I think, because it's a Good Samaritan Act is really the entire argument. But I don't know how that breaks up. So issue 1, issue 2, I don't know how many issues there are, but we'll just put some placeholders in there. All right, I'm going to go back to the materials. So somebody asked that, they've seen on a PT that where there was an MSJ, they noticed that they simply concluded for the last issue, that the defendant's entitled to judgment as a matter of law. What you should be doing here is you should be arguing that for each issue, there's no tribal issue of material fact such that you're entitled to judgment as a matter of law on each issue. So we're going to see this in here. So step 3 is what we're on right now. This is skim the file. Just do this really quickly and make notes of what it is. So this is this is defendant Depot. This is our client. So when there's a big transcript, I usually am not going to really get a whole lot of it. What I try to do to skim is I just read the first line of any big paragraphs. So Route 12 is a 2-lane country road. There was heavy fog, traffic was sparse. As I drove east, I saw a van in the ditch on the side of the road. I also saw another car stop in the road near the truck, but that car drove off. I'm not sure about the hazard lights. I might have had a reflex kind of thing. I didn't pull it off the road. There was virtually no shoulder that I could pull the semi onto. I rolled down the passenger window and asked Tram, "Are you okay?" So it sounds like there's an accident. He's pulling over, trying to provide some help, right? I asked Tram if he wanted me to call 911. Tram said, yeah. And then immediately after Tram said yes, Panko's car rammed into the back of my semi without even trying to brake. Okay. This is a deposition of Rebecca Higgins. I don't know who that is, but I'm just going to make a note. This is the Higgins depot. I want to identify who this person is, ideally. Okay, so it says, I was traveling on westbound on Route 12. So it looks like this is a witness when I saw a semi truck. So witness, I think. I slowed down and pulled past the semi, parked on the side of the road opposite. At that point, I had to turn my head a bit. I saw the back of the semi. I saw the semi's brake lights on. I saw who I thought was the van's driver, later found out. Okay. He was standing next to the passenger window of the semi. It looked like he was talking to him. I turned on my car's beams to warn Panko, but he did not slow down. So it looks like we have our client pulled over to help somebody at the side of the road who is in distress, who had gotten in an accident. Then we have this other witness who, and when he pulls over, the plaintiff rams into the back of our client's car or truck, semi truck. You have another witness, this Higgins person, who watched this, who she pulled over to help on the other side of the road, and she sees that the plaintiff, Panko, just rammed into the back of our client's truck and tried to warn him that there was a truck there and nothing happened. Excerpt of affidavit of Brian Tram. I simply don't remember much of what happened. I was in a daze. I've just got snippets. Okay, so this is the Tram affidavit. I label the first page of each unique document within the file because I want to be able to like flip through it quickly and find what I'm looking for. So if I label it, it helps me to see, okay, this is that document versus like having to skim it at all. So that's why I write it in the top right corner. Then excerpt of transcript of deposition of Anton Panko. So this is plaintiff depo. Okay. So as I've said many times, I was driving on Route 12. He sounds a little irritated. Well, just out of the blue, I see the semi truck parked in the middle of the road. I remember seeing the rear of the semi prior to the collision, but I'm not sure. No, it was in the eastbound lane. I mean, that was the problem. He's saying you should have pulled over. Did you hear any conversation? No. The only one I saw is a woman named Rebecca Higgins when I got out of my car. Okay. So that's it. It's just transcripts from a witness, the plaintiff, the defendant, and an excerpt from the person who had gotten initially in the accident. Okay, now we're going to get into the library. So we're going to skim and read. And I really want to try to figure out what are the issues that I need to address here. So I get the Good Samaritan Act, I get Chung v. Delva and Miller v. Jones. So I get these three cases, or the statute and the two cases rather. So I want to make a note. This is GSA, the Good Samaritan Act. Gratuitous. So if I get a statute, this one is not super long, so I'm probably going to read it. If there was a lot of statutes, I just do a skim. But this I actually want to read to see what's going on because I need to figure out my issues and I need to figure out, what am I trying to analyze under the Good Samaritan Act? So gratuitously rendered emergency care. So the section does not apply to services rendered by a healthcare provider to a patient in a healthcare facility. So I want to address this, that my client is not a healthcare provider. So this might be a little issue. A person who comes upon the scene of an emergency or accident or is summoned to the scene of an emergency or accident and, in good faith, gratuitously renders emergency care at the scene of the emergency or accident is immune from civil liability for any personal injury that results from. So I have to show that he's in good faith gratuitously rendering emergency care at the scene of the emergency or the accident. So they're immune from civil liability from injury that results from any act or omission by the person in rendering the emergency care, or any act or failure to provide or arrange for further medical care or further medical treatment or care for the injured person, except for acts or omissions amounting to gross negligence. So it looks like I have to show that they were gratuitously rendering emergency care at the scene of the accident, and also that that their conduct didn't amount to gross negligence. So these are what I think my issues are, I think. But I want to go to the library, the rest of it, to be sure. Here I have Chung v. Delva. So when I'm skimming and reading a case, and actually, let me take a step back to this. Deconstructing statutes is difficult. So this is something we practice in my PT class. It's something you absolutely need to practice because if you get a statute, you want to understand how to actually like deconstruct it and pull it apart. I know here that there's really these two issues because I know how to read and deconstruct a statute, which I'm not going to go in and do like a whole lesson on that right now. But I know looking at this, what they're looking for is that I'm acting in good faith, I'm gratuitously rendering emergency care, and I'm not going to be liable for any injury that results from either of these scenarios in one or two, and that there is an exception so that for anything that amounts to gross negligence. So it's really, I have to show that he's gratuitously rendering the care, and that if there was an issue when I was rendering the care, I wouldn't be liable. And yeah, and that for any act of failure to act and provide for further medical treatment or care for the injured person, that there would be no liability. So, and one thing I want to point out too is that this here says this is in talking about the injured person, and in point one here, it's just for any act by the person who's my client that was rendering the emergency care. So anything they did that was negligent, they could be relieved of liability. So when I am skimming and then reading the case, I want to read the first line and I want to identify, is this just facts? Is this facts, or is this getting to like rule and analysis? I don't read these introductory fact paragraphs. I haven't read them here. I don't ever read them. I haven't read them for any of the PTs. So just throwing that out there, the relevant facts will be in the analysis section of the case. So here it says, Hannah A. and Kwan A. Chung appealed from a summary judgment. So this is facts. While returning to their home, the Chungs encountered blizzard-like driving conditions. This is facts. Before Mr. Chung got back to his car, a second semi-tractor and trailer. This is facts. The Chungs settled with Hopita for injuries. So here it's getting into the case and it's getting into procedural history. So that's when I start paying attention and reading. So I'm skipping an entire page from the library. I'm not getting hung up in the facts. I'm not trying to track everything that is going on. So I'm just really I'm just trying to get to the procedural history. That's when I slow down, which is down here. And I want to get any rules. I want to start extracting rules and identify where the analysis of the issues are. So the Chung settled with Hopita for injuries sustained from the first collision. In September 1998, the Chungs brought this action against Delva, seeking to recover damages for personal injuries allegedly suffered from the second accident. Delva filed a motion for summary judgment claiming the GSA barred the Chungs' action. The trial court concluded that because Delva stopped to see if anyone at the accident scene needed help, the Chungs' action was, as a matter of law, barred by the GSA. The Chungs appealed from the summary judgment dismissing their action. Now I see the next line. Summary judgment is a procedural device. So this is a rule for MSJ. So I am deconstructing, I'm labeling the paragraphs and I'm highlighting and just really deconstructing this. Summary judgment is a procedural device for promptly disposing of a lawsuit without trial if, after viewing the evidence in the light most favorable to the non-moving party, there are no genuine issues of material fact. While any two parties in a lawsuit may allege that the facts are in dispute, the disputed facts must be material. In simple terms, if the disputed facts do not change the result, regardless of how the dispute was resolved, they are immaterial. So that's giving us a little bit more of an explanation of what is a material fact, what are we getting at with an MSJ. That is definitely some additional rule that you could include. We just really need the standard though. But I'm just going to highlight this because if I was a bar taker, I wouldn't maybe be confident that I could absolutely omit that. But this is everything for an MSJ. Then we have Columbia's GSA. So here's the statute. The rule for the GSA. Bars action against a person who gratuitously and in good faith renders aid or assistance at the scene of an emergency or accident, except for acts or omissions amounting to gross negligence. So if you're not so good at deconstructing a statute just from the statute itself, they often do it for you in the case. They'll really distill it down to what's important. So bars actions against a person who gratuitously and in good faith renders aid or assistance at the scene of an emergency or accident, except for acts or omissions amounting to gross negligence. So here we have a general rule and then we have an exception. So you have 1 and you have 2. So these are my 2 issues. So maybe here at this point, I would go and put my headings in my document, but I'm in a groove here, I'm reading, it's fine. Emergency care is statutorily defined to mean any actions which the aider reasonably believes, so this is a rule, for emergency care. Any actions which the aider reasonably believed were required to prevent death or serious permanent injury, disability, or handicap, or reasonably believed would benefit the injured or ill person, depending on the aider's perception of the nature and severity of the injury, illness, and the total emergency situation, and that the aider reasonably believed the aider could successfully undertake. So that's what emergency care means. Okay, so there's a rule there. I'm going to highlight that. When I'm highlighting my rules, I'm also looking for how can I kind of cut this down. So emergency care is, it doesn't matter that it's statutorily defined to mean any action which the aider reasonably believed were required to prevent death or serious permanent injury, disability, or handicap, or reasonably believed would benefit the injured or ill person, depending upon the aider's perception of the nature and severity of the injury or illness and the total emergency situation, and that the aider reasonably believed the aider could successfully undertake. So that's what emergency care means. So there's been this section on rules, right? Rules for an MSJ and then rules for the GSA. Then it gets into discussion of the facts of our case. This is why you do not need to read the facts in the introductory paragraphs, because the important facts will all be in the analysis section. So we're getting into the analysis here, and there's a lot of it. So the Chungs argue the trial court erred because merely stopping at the scene of an automobile accident and inquiring whether any assistance is needed does not, as a matter of law, constitute rendering aid or assistance within the meaning of the GSA. So I know that I'm getting into the analysis because it's talking about the specific parties of the case in the library, but I'm not going to highlight everything. They often do this where they tell you what a party argued. So all I care about is what does the court say about this argument. So we're getting into the analysis, so I'm just going to label this analysis. The Chungs also argue in the alternative that summary judgment was improper because it is unclear what Delva's intentions were when he stopped the semi-tractor and trailer on the highway. We reject the Chungs' contention that the act of stopping on the side of the road at the scene of an accident to inquire whether any assistance is required cannot constitute rendering aid or assistance under the GSA. Our primary objective in construing a statute. So here they're talking about like what they do when they are construing the meaning of a statute is to ascertain the intent of the legislature by looking at the language of the statute itself and giving it its plain, ordinary, and commonly understood meaning. Statutes are to be construed in a practical manner. Then it says the obvious purpose. So here this is policy. Whenever they tell you what the reason for a rule is, that's policy. Policy is something that you can always include, but it's usually not necessary. So if you're someone that always runs out of time, it's good to identify the policy and maybe incorporate it into your argument. You might not type it in. A better answer will incorporate the policy. You'll write the policy out and you'll incorporate it into your analysis. So I like to distinguish though between policy and a rule. A rule is a rule that you can take and generally apply it to a given set of facts. The policy is the reason we have the rule. So the obvious purpose of the GSA is to encourage those who do not have a pre-existing duty to voluntarily act in times of emergency by limiting the threat of civil liability for the actions taken. So that's what they say. And then we get to a rule. Stopping at the scene of an accident to assess an apparent emergency situation and to learn whether assistance is required will normally be the first action by a person willing to help if the circumstances warrant assistance. The Chung's argument that the GSA does not apply until life-saving affirmative action measures or action undertaken is not supported by the broad statutory language and is inimical to the purpose of the act. So the court here says stopping at the scene of an accident to assess an apparent emergency situation and to learn whether assistance is required. They're saying that that can be emergency aid. So just merely stopping can be emergency aid. We nevertheless reverse and remand for trial because genuine issues of material fact exist which preclude the granting of summary judgment in this case. So under the terms of the GSA, Delva had to establish at least one of two things to have rendered aid or assistance necessary or helpful in the circumstances. One, that Delva rendered actions which he reasonably believed were required to prevent death or serious injury, and he reasonably believed he could successfully undertake, Or 2, that Delva rendered actions that he reasonably believed would benefit an injured or ill person, and he reasonably believed he could successfully undertake. So there's this issue. So in rendering emergency care, you have to show that that the actions that he undertook, he was taking them and he reasonably believed it would be required to prevent death or serious injury, or that he believed that his conduct would benefit an injured or ill person. So essentially you were pulling over or you were trying to provide aid, and that's the reason you pulled over. Moreover, so this is just getting at the rule for what is required for immunity, 1 or 2, and it's an alternative. Moreover, each alternative must be judged from Delva's overall perception of the nature and severity of the injury or illness and the total emergency situation. This is just repeating the rule that we have seen previously. Thus, the statute combines elements of the reasonable person standard as well as the aider's subjective state of mind. Generally, issues involving the reasonable person standard and a person's subjective state of mind are inappropriate by disposition by summary judgment. I see that and I'm like, oh, I want to get a motion for summary judgment granted, and it involves a reasonable person standard and a person's subjective state of mind. So this right here is not so great for me. So whenever I see something that doesn't look beneficial to me, I want to use that. I want to address that as a counter argument. So I want to say, look, I know that generally issues involving the reasonable person standard and a person's subjective state of mind are not appropriate for summary judgment. Despite that, it's still appropriate in this case. So this is probably my counter argument. Additionally, when the nature of an emergency situation is not clearly apparent, the question whether there existed an emergency situation that warranted application of a Good Samaritan law has been held to be an issue of fact not amenable to summary judgment disposition. So also that. In this case, and now here we get to the analysis again. Oops. In this case, the trial court found it is uncontroverted based upon Mr. Chung's own deposition testimony that Delva stopped his truck at the accident scene to determine whether anybody needed help. However, Delva presented no direct evidence showing his own state of mind or why he stopped the truck. So I'm going to highlight this. This is my analysis. Delva presented no direct evidence showing his own state of mind or why he stopped the truck. There was no affidavit, deposition testimony, or other evidence from Delva addressing these questions. At most, the facts show Delva stopped the truck, the passenger's window was rolled down, and the passenger asked whether everything was okay. Although Mr. Chung testified Delva stopped to see if everything was okay, Mr. Chung further testified he did not talk to the driver of the truck, and he believed the passenger had his window rolled down because he was trying to see the side of the road. I don't know. So here, and so this isn't good for us, right? So here, the facts, the court says that it's not appropriate for an MSJ. And the reason it's not appropriate for an MSJ is because it's not apparent based on the evidence why the driver pulled over. It's not clear that he's pulled over to provide assistance. So I need to distinguish from this case because I want to argue that there is no tribal issue of material fact, that he absolutely was pulling over to provide emergency care, and there is ample evidence supporting that. So this is analysis. Oops. And I want to distinguish because it comes to the opposite conclusion. So this is the analysis. Delva presented no direct evidence showing his own state of mind, why he stopped the truck. There was no affidavit, deposition testimony, or other evidence from Delva addressing these questions. At most, the facts show Delva stopped the truck, the passenger's window was rolled down, passenger asked whether everything was okay. Although Mr. Chung testified Delva stopped to see if everything was okay, Mr. Chung further testified he did not talk to the driver of the truck. He believed the passenger had his window rolled down because he was just trying to see something. Besides the lack of direct evidence of Delva's intentions and state of mind, other reasonable inferences could be drawn from Delva's act of stopping the truck. Delva's passenger may have had the window rolled down in an effort to maintain eye contact with the side of the road for navigational purposes. Alternatively, Delva may have seen the initial accident and slowed the truck as a precautionary measure, and because of the icy conditions, wind, and slow speed, he was unable to continue, simply stopped at a point near Mr. Chung. Other reasonable inferences could be drawn. After stopping the truck. So I'm gonna highlight, just pull out what I think are the relevant facts from this. As a precautionary measure, because of the conditions, he was unable to continue and simply stopped at a point near Mr. Chung. Says, moreover, even if Delva stopped the truck to ask whether everything is okay, there is no evidence Delva actually intended to provide aid or assistance. This is more analysis. Or to what extent he would have been willing and able to provide assistance if assistance was needed, nor is there evidence Delva believed he could reasonably undertake any required actions, even if he, in fact, intended to provide them. The trial court's opinion does not address the reasonableness of Delva's beliefs, which is a statutory prerequisite for immunity. So I know that I need to provide I need to explain the reasonableness of my client's beliefs, right? So there's no evidence he actually intended to provide aid or assistance, to what extent he would have been willing and able to provide assistance. And we don't know if he reasonably believed he could undertake any required actions, even if he did intend to provide them. Undoubtedly, there will be cases in which immunity under the GSA can be determined under the summary judgment standards. This is not such a case. A reasonable person could draw more than one conclusion from the evidence in the record. Under the unique circumstances of this case, we conclude there are genuine issues of material fact, whether Delva is entitled to immunity under the GSA, and the trial court erred in granting summary judgment and dismissing the Chung's action. So all of this is really about the whole first part of the GSA, about did you believe that you could provide emergency aid, etc. So that's what this case is about. It comes to the opposite conclusion from what I want, so I need to distinguish from it. There's also a ton of analysis here, which tells me that this is a really big issue. You can always look to the division of the library to determine how critical an issue is. So let's look at the next case. So then we have Miller v. Jones, which you can just call it Miller. Somebody asked me, what do you mean when I was talking about policy? What do I mean by you don't usually have to include the policy? The policy is the reason for the rule. It's not a rule that you actually apply. So that's why you don't have to include it, but it is something you can use to support an argument. You can say, look, the policy, applying this way, taking this interpretation of the law as it applies to the facts is in line with the policy. So this is something, policy use is a little bit more advanced. I get into that in the full course. So if you struggle with any of these things, definitely check out the full course that we have, which doesn't start till next week. So still plenty of time. And I'll put the link again to the course in the chat if y'all want to check this out. And we go through all of the steps of the PT process in depth in the class. We cover a ton. You do some practice in class 4. We cover just the general approach. We cover objective PTs, persuasive PTs, and like a whole bunch of like really difficult and odd PTs as well, so that you will be prepared for anything. All right, so let's talk about this. Let's look at the second case. So same thing. We're going to just skim until we see that there is procedural history, and then we're going to start reading. And for the essays and PTs prior to class, yes, you can. We definitely allow you to print the essays, print the PTs prior to class. So yeah, you absolutely get to, you absolutely have that. So following a non-jury trial, Andrew Miller appeals from decision. So this is just facts. On December 1st, 2006, Miller was involved in an accident. This is facts. Miller argues that, okay, so now we're kind of getting to an argument. So we're getting really to the procedural history, or like what happened, why we are here in this court now. Miller argues that because the court's findings do not indicate that he committed gross negligence, they are insufficient to support the judgment awarding punitive damages. So it looks like this case is getting at gross negligence. Gross negligence is defined as a conscious voluntary act or omission. And I want to label this. In reckless disregard of a legal duty and the consequences to another party. And they cite this other case, not a big deal. You might include a little bit more detail. So gross negligence is the intentional failure to perform a manifest duty in reckless disregard of the consequences or callous indifference to the life, liberty, or property of another that may result in such a gross want of care for the rights of others and the public that a finding of willful, wanton, deliberate act is justified. To establish gross negligence, so one thing I want to say about this is I want to take the shorter of the two rules. Here, what they are doing is they are citing to this other case and giving the actual language, but they're stating the rule in a more succinct manner. It's just repetitive. So you don't need to actually include both of these. The first rule is shorter, so I'm going to include that one. To establish gross negligence, I do want to include this. A party must demonstrate ordinary negligence and must then prove that the defendant acted with utter unconcern for the safety of others or with such a reckless disregard for the rights of others that a conscious indifference to consequences implied in law. So this is, again, another rule for gross negligence. Yeah. And then we get into analysis. Now they're talking about what happened at the trial court. So at no point did the trial court's findings indicate that Miller committed gross negligence. Instead, the findings indicate merely that Miller was negligent. So they say that there was no gross negligence and why. When I'm looking at the analysis, I want to identify what did they hold regarding this issue and why. So the distinction is not merely semantic. Indeed, our Supreme Court has recognized that when comparing negligence to gross negligence, and that goes back to a rule, the level of conduct amounting to a breach of that duty is quite different. As the court failed to find that Miller's conduct constituted gross negligence and it made a specific finding of mere negligence, its findings were insufficient to support the judgment awarding punitive damages, which requires gross negligence. Further, the court's factual findings are insufficient to support a finding of gross negligence. The question of whether an act or omission constitutes gross negligence is generally a question of fact. That's a rule. I'm highlighting my rules in pink. I always think like red rule, but I always think like I try to always do that. So I do pink because it's if I highlight it in red, you wouldn't be able to see it. Yes, you can have different colors of highlighters during the exam. I don't really recommend doing that. I do it. The way that I want you to really mark up in the exam is to label it. So like here is rule. I would just do brackets and label it, but I like to do the different colors because I'm teaching and I want to make like a visual representation for you all. But on the exam, I wouldn't be fussing around with different color highlighters and stuff. As in a summary judgment motion, however, the question may become one of law if the facts are undisputed and only a single inference can be drawn from those facts. Here, the facts are not disputed. The reason why they held this way is because of this. Miller approached an intersection, stopped at a stop sign, proceeded into the intersection, and struck a vehicle that he had not seen, claiming that it was in his blind spot. We conclude that these facts, as a matter of law, indicate that Miller was negligent, but not grossly negligent. So here, they held that there was simple negligence, not gross negligence, because of these facts. Nowhere in its findings does the court indicate that Miller engaged in any sort of conduct with reckless disregard. This is also its reasoning. Indeed, the court found that Miller's actions may not have been intentional, but if the claimant had a blind spot, he should have taken more care in looking both ways. The fact that Miller did look both ways clearly indicates that he did not recklessly disregard this duty to other drivers. Indeed, Miller did not disregard his duty at all. He merely failed to adequately meet it. Therefore, Miller was negligent, but his regard for other motorists precludes a finding of gross negligence. We conclude the court's findings fail to support its judgment, and the evidence fails to support a finding of gross negligence that would justify an award of punitive damages. And as I'm going through and highlighting the facts, you could just highlight, everything that is analysis. What I'm doing that's a little bit more advanced, I suppose, is I'm not highlighting facts that seem repetitive to me. So I'm going through and I'm highlighting my facts, but if it just looks like it's repeating something, then I'm not going to include it because I don't want to type in things that are repetitive. So I'm trying to highlight the facts that I am going to use in drafting my rule proof. He merely failed to adequately meet it. Okay. And that's it for the library. So you can see here that there is less analysis. There's still a bit of rule, but this case is just dealing with gross negligence, which is the second issue. And the whole first case is there is a lot more analysis. So it looks like the first issue is the bigger issue. It's going to take me more time, but I still need to save time for the second part. So first it's, did you meet the requirements of the Good Samaritan Act? And did you act with gross negligence? So I'm going to put in my issues here. So my first issue is, let me go back down to this. I pulled it from the library. Gratuitously rendered emergency care. Okay. So issue one, they didn't give us instructions on whether, on how to write our headings, but I generally like to write, if it's a persuasive document, so you should write them persuasively. And I like to incorporate a little bit more facts and law, but this should be a conclusion statement for your heading because this is a persuasive document. So, and I always want to tie in the standard. So there is no triable issue of material fact regarding whether, I usually don't care about typos, but that was a pretty bad one, regarding whether Mr. DeHere gratuitously rendered emergency care at the scene of an emergency, and he is therefore entitled to judgment as a matter of law. And then the second issue is there is no triable issue of material fact regarding whether Mr. DeHere acted with gross negligence, and he is therefore entitled to judgment as a matter of law. So these are my two issues that I have. You might break down the first issue into a couple of sections. You don't necessarily have to. But so I've gone through the whole file and library. I'm going to use, so under this issue, so I make an annotation when I put in my headings. I put a note for rule. This is rule proof. This is for analysis. You're not going to have one analysis paragraph. You're going to have several. This is for any to note counter argument. I'm going to have counter argument paragraph. Each of these is a paragraph. So paragraph for my rules, paragraph for my rule proof, paragraph for analysis. There's probably going to be several of these. Paragraph if I have a counter argument for this issue, and then a conclusion for this issue. They said they didn't want an introduction and conclusion. They're talking about an intro and conclusion section, but I still am going to conclude for each particular issue. So here for the rule, I'm going to use the Good Samaritan Act, and I'm going to use Chung. For my rule proof, I'm going to do a rule proof of Chung. My analysis, I know that I need to come to the opposite conclusion because I want to say that we are entitled to summary judgment. So here I'm going to make a note that I'm going to distinguish from Chung. I have several, my analysis might be a few paragraphs. I don't normally write that, but just wanted to show you all. Counter argument. I had some counter arguments from Chung. So I'm just gonna make a note, Chung statements. And then what's my conclusion, right? You don't need to add a note. And then what about this one? So my rule is from, again, the GSA, but it's also from that second case, Miller. I'm going to do a rule proof of Miller. And in Miller, they said there was no gross negligence. I'm going to analogize to Miller. I didn't see a counter argument for this issue. I think if anything, you could maybe argue that if at most our client was negligent, but it's still not gross negligence. So I'm going to say simple negligence, question mark, if I have time, and then my conclusion. Then the next thing would be to go back through this and type in my rules. This is why it's important to label everything. I'm going to type in my rules as necessary. So here's my rule for MSJ. So I'm going to type that in here. Here's my rule for the GSA. Here's a rule for emergency care. So this section, I'm going to pull the rules from GSA and Chung. I'm labeling my analysis. I'm going to have a rule proof that incorporates all of this important analysis and the various issues that are in here. Yeah. And then after I go through, so as I'm going through each case, I can never do it on the screen because I can't have my iPad pulled up and share the doc. But as I'm going through, if I read one case, I'm going to go through, okay, this case is being used for issue 1. I'm going to make a note. Okay, so the rules for issue 1 come from GSA and they come from Chung. I'm going to do a rule proof of Chung. I'm going to distinguish from Chung and what my potential counter argument. The rule proof is something that it's explaining what happened in the case. A rule proof, it can be, it's usually not multiple paragraphs, it's one paragraph. It might be several sentences. I have my answer that you guys were going to email to everybody, my answer to this one, because I have written a complete answer. So a rule proof is explaining what happened in the case, what the court held, and why. I go into this in depth in my PT book and in my courses. It's not something I have time to go through tonight. It's not something I do in these free workshops generally, but you have to explain what happened in the case. So as I go through the case, I'm going to make a note as to where that case belongs, where that section of the library belongs. Then once I'm done, I still have my library open and I just go through and I start typing stuff in. So I'm going to type in the standard for an MSJ and I'm going to type in the general big rule for the Good Samaritan Act. And then I would type in my rules and then I would draft my rule proof of each of these. So we're going to send out our answer, but I just wanted to show you really pulling apart the library, the task memo, setting this up, figuring out the issues. There is a lot of analysis. So my rule proof for this would be really long. In my answer, you will see that. And no, I do not think you should do the PT first in the second half. I talked about that earlier. You should do it, just do everything in order. If you start with the PT, you are going to borrow time from your essays and you're not guaranteeing you're going to get a higher score on the PT because you should be able to finish it in 90 minutes. And you're just almost guaranteeing that you're not going to pass the essays. So I wouldn't do that. All right. So if y'all have any questions, please feel free to reach out. You can always reach us here at hello@bar-md.com. We will send out my full answer to this particular PT. Hopefully I see y'all in the upcoming PT course. Check out my PT book, all of that. And we do have another PT workshop I'm doing, I think in another week and a half or 2 weeks. So make sure you sign up for any of those free workshops that I'm doing. And thanks so much for joining me. And yeah, Alberto, you do have access to past material. Yeah, so there was a survey that we sent out, so you should have filled that out. So if you need the re-registration survey, okay, so just shoot us an email. Because my team has gone through all of them. So, okay, cool. All right, thanks everybody. Have a good night.